Wait, please, my lord. This matter pertains to the compensate appointment of the petitioner, my lord. It had listed last month 110, last month, my lord, and your lordship directed to be listed again after 3 weeks. More than a month is gone, my lord, and the matter is not been listed. My prayer is, my lord, let it be listed for admission, my lord, on first week of December.
To withdraw the petition, my lord, I may be allowed it on 25th Monday.
Yeah, please, I beg to mention for listing for admission, my lordship.
What is the matter?
Matter is a contempt petition, lordship. It is last contempt petition, last listed on 26/7/2023, lordship. After it is not listed.
Second week of December. You write second.
For listing on 25th, my lord.
Hmm.
They already an affidavit filed that on November, they are going to release the retirement benefit. But unless there is a judicial order, it will not be released. My lord. Therefore, I am praying on 25th.
This is for what?
It is for,
This
it is
is for
for
what?
listing for admission, my lord. Because the affidavit in file that by November, they are giving part of the amount of the retirement.
26th.
26th, madam. Okay.
May I please, your lordship, I beg to mention for listing on writ petition, lordship, for orders. Can it be on Monday, lordship?
Second week of December, second week.
I plead to lordship. I beg to mention for withdrawal of WPC. Withdrawal.
When you want it?
Tomorrow, lordship.
May I please, your lordship? I beg to listing of the WPC, your lordship. Lordship, this matter last listed on 15/5/2023.
What is the matter about?
Promotional matter, your lord.
Second week of December.
Okay.
My lord, I beg to pay one matter, my lord, contempt matter to be listed on 27th of my lord.
First week of December. Not 22nd.
Could I mention the, my lord?
Actually,
the
contempt, there is no question of mention. There is no urgency in contempt, but still.
well, actually, my lord, I'm the court ordered for my lord, disbursement of the pension amount, my lord. I'm not getting that, my lord. That's why.
All right, first week of December. Yes.
Lordship submission. Lordship submission, my lord.
First week of December, you write.
So, my lord, matter for tomorrow and what had happened is, my lord, I filed a writ petition against a junior superseding mean service. He was placed in charge. And my lord, when he received a copy of the writ petition, he has now given me a show cause. That in charge person has given me a show cause to reply within 5 days why disciplinary action should not be taken against me on the representation and on approaching the court. It will be taken up tomorrow. My lord, the 5 days expire tomorrow. They gave it to me day before yesterday. Expires tomorrow, Monday, he may take an action against me or there will be another litigation, long litigation.
Then what will happen? What action he will take on Monday?
My lord, there have been instances where he has terminated on that.
Within 24 hours?
He terminates, my lord. That is what is happening. It's the LGBI, if lordship remembers, my lord, where that problem is taking part, the in charge director coming in, a junior.
If he is terminated, we'll stay it on Monday.
On Monday, I'm obliged.
But you do your part. You do your part. If you have to make a reply, you make your
The
reply.
reply, he has given me a show cause why I filed a representation. Challenging this appointment. My lord.
All right, if that is the ground of termination, we'll stay it.
That is what my lord.
But you can't say that I will not reply because you are not
I
right.
will not reply on that.
Reply, you reply.
For admission, item 1.
My lord, in this series, my lord, 1 to 5, I am for 1 and 2, my lord. In 3, 4, 5, my lord, the learned senior counsels, my lord, are engaged, my lord. They have some difficulties. My lord, they have requested.
My lord, item number 3, I'm led by Mr. K. Chaudhary, my lord. He's filed his leave of absence, my lord.
Plus, your lord, if I'm not wrong, in this order, the last order, it has been given that fixed for hearing. It has come possibly in the admission.
So these matters are to be fixed for hearing.
Hearing.
So, can it come up any hearing day in the month of December, my lord? Because
When do you want it?
on a hearing day, my lord, December.
When possible, my lord. If possible, my lord.
17th of December. Learned counsel for the petitioners are present. Learned counsel for the petitioners in the respective writ petitions are present and submit that these matters are ready for hearing and therefore be listed for hearing on a non-miscellaneous day in the month of December 2024.
Mr. C.S. Hazarika, learned Government Advocate Assam, is present and does not have any objection to the said prayer. In view of the above, let these read petitions be listed on 17th of December 2024
There's
for
an
final
interim
hearing
order operating in item number
as
3.
fixed items. Interim orders passed earlier to continue till then.
Item 6.
Please, your lord.
Yes.
My lord, the stand of the petitioner is the claim of the petitioner, my lord. They are claiming, my lord, medical reimbursement scheme, my lord, under they are pensioners, my lord, of the erstwhile ACB and its successor companies, my lord. Now, they have already filed a reply, my lord, and their stand is that, my lord, since the ACB is suffering from financial loss, my lord, so it cannot be considered, my lord. Otherwise, they have admitted that the petitioners are eligible for the medical reimbursement scheme, my lord. And that claim is based on the, my lord, your lordship will find, my lord, Annexure 6, my lord, at page 55, my lord.
Annexure 6 is at page 54, not
My lord,
55.
it starts from 54, my lord.
Yes.
Relevant portion is, my lord, 55, my lord.
Yes.
Well,
Your lordship will find under,
if your lordship permits, my lord, already pleadings are complete, my lord. If your lordship allows, my lord, may I fix it for hearing, my lord, because KP Pathak is appearing in this matter, my lord. So today he is not present, my lord.
already, my lord, they have filed their
Yes, my lord.
opposition, my lord. We have filed a reply, my lord. My lord, simple matter, my lord. Lordship may dispose it of actually by hearing, my lord, admission hearing.
Mr. Pathak is not present today.
Yes, my lord, because of his younger brother's marriage, my lord. Tomorrow is fixed, my lord.
Next week, my lord, fixed matter, my lord.
Yes, my lord. That can be done, my lord.
No, what will happen next week? You will get the reimbursement the
No,
week
my lord, no,
thereafter.
my lord.
Then
No, my lord.
why are
But
you
lordship can give a direction, my lord,
Hmm.
to consider, my lord, or to at least, my lord.
that is your prayer.
My
You
lord,
may or may not accept it.
My lord, that
But
is,
the point here is he is having difficulty.
My
What
lord,
is to be done?
let them, as per their convenience, my lord. Let them fix it. Take a date, my lord.
Mr. S. Parasal, learned counsel is present for the petitioner. Mr.
B does, my lord.
B. Das, learned counsel appearing to the respondents submits that the learned standing counsel APDCL, who is supposed to argue the matter, is not available today. Therefore, this matter will be fixed on any other day for admission hearing. On the request of Mr. B. Das, this read petition is directed to be listed again on 3rd December.
But,
2000.
well, I'm only for the respondent number 1, my lord.
The
APDC.
respondent number 1.
Yes, I'm obliged, my lord.
3rd December.
My lord.
The state was directed to get some instructions. In fact, I think they were required to file an affidavit.
Lordship, I also think that instruction I have received, Lordship, but it will be better, Lordship, if I file an affidavit, Lordship, so that the other side gets an opportunity to file reply, Lordship.
Yes. Mr. P. Nayak, learned standing counsel finance department submits that in terms of the order dated 5/11/2024 passed by this court in this batch of writ petitions, necessary instructions have been received by him. Stop. Therefore, Mr. Nayak seeks 10 days time to file affidavit, bringing the said instructions on record. The prayer made by Mr. Nayak is not opposed by the petitioner's counsel as well as Mr. I. Chaudhary, learned senior counsel appearing for the private respondents. In view of the above, let this matter be listed again after 2 weeks. The affidavit be filed in the meantime by serving advance copy upon both the parties. Lordship.
Not JP, if it is not inconvenient, then
After 2 weeks as fixed item.
12th month.
List again on 12th of December.
Item 10.
Lordship, can it be on 14th, Lordship?
Why?
14th.
14th is a Sunday. We don't come to court.
14th.
16th.
Let it be 12th. We'll see.
Yes.
Item 10.
Yes.
Item 10.
Who is appearing?
I, Rafiq. Lordship, similar set of writ petition has already been disposed by your lordship.
Which one?
Similar matter, your lordship, earlier disposed, my lord.
Dispose.
Yes, lordship, 5440.
So, same
Lordship,
order.
same.
Take down, had Mr. I. Rafiq Leonard, counsel appearing for the writ petitioners. Also heard Ms. M. Bhattacharya, Leonard additional senior government advocate Assam, appearing for the state. It is submitted at the bar that this writ petition is covered by the order dated 29/10/2024, passed by this court in WPC number 5440/2024. Full stop. In this writ petition, the petitioners have expressed apprehension that their services may be terminated without following the due process of law. Full stop. On 29/10/2024, this court had passed the following order in WPC number 5440/2024, which was instituted by similarly situated petitioners expressing similar apprehension. To court code order to since the parties are in agreement that the present case is covered by the order dated 29/10/2024 passed by this court, this writ petition stands disposed of by making the said order applicable in the present case as well. Yes.
Lordship, this matter has been fixed for endeavor shall be made to dispose of the matter today, Lordship. But Lordship, I contacted your Lordship to the order dated 19/9/2024, wherein a coordinate bench has already heard this matter.
Why it has been listed for orders today?
Should have come up for admission. here.
Admission.
Sorry?
It should have been listed for admission
Admission.
because there is an order for disposal, ma'am.
Order dated 19/9, it was heard at length, your Lordship. And for further hearing, matter was fixed on 7/11/2024, your Lordship.
Matter has been heard by
My
another.
lord, in several courts, it was heard, my lord.
19/9, your Lordship, may kindly have a look.
Nowhere it is part heard, my lord. আগে শুনছে বুঝছে না ঢুকে নাই আর বুঝছে না
It's written further hearing. The order mentions further hearing.
Koshi Goswami.
You have not seen that. Further hearing means part heard. Not heard Ms. B. Bhuya, learned senior counsel appearing for the writ petitioner. Also heard Mr. J. Bhuya, learned counsel appearing for the respond numbers.
Respond number 9 and 10, my lord. In
9
other
and
case,
10.
I'm 10, I'm here.
Sir, report to Mr. D. Majumdar. Learned additional AG Assam.
in 19
expressed on behalf of the state. Ms. P. Sharma, learned counsel has appeared for the APSC. Thanks, Jay This writ petition,
My lord, one
these matters have been posted for orders today. However, it has been pointed out at the bar that the writ petition was heard in part before a coordinate bench and by the order dated 19/9/2024, it was directed to be listed again on 7/11/2024 for further hearing, within course
7/11.
further hearing. Full stop. If that be so, it is clear that this matter is part heard before a coordinate bench, registered to therefore examine the order dated so-and-so and list the matter before the appropriate bench in the next week.
Interim order may continue
Interim
till
order
then.
passed earlier to continue till the next listing.
Deeply on.
The matter may pass away for the time being, lordships.
What is the matter about?
My lord, it's challenging a major penalty. There was an interim stay order, but I have been superannuated from my service, and they are withholding my all my retired benefits, saying that the matter is subject, that which they can't do it because now they can't impose the penalty. So I have moved an they were supposed to file a reply. They did not file.
No, just a minute, just a minute.
Oh, sorry.
Your client was in service under which department?
Assam Gramin Vikas Bank. And this is a case covered by your lordships earlier, one of the judges.
Just a minute. Let me understand the facts.
Yes.
So there was a disciplinary proceeding initiated against him while he was in service.
Yes. Then, then I came before this honorable court challenging the major penalty of reducing my.
Oh, just a minute. Then penalty was imposed on him again while he was in service.
Yes.
Correct. Then what happened?
I came before this honorable court. This honorable court said that you go to the appellate authority. I went to the appellate authority. They simply uphold the order of the disciplinary authority. It's a cryptic, non-reasoning order that has to go. But in the meantime, during the pendency of this writ petition, I have been superannuated from my service. 31/7/2024. And now they are not giving me my retired benefits.
So your case is that since you have retired, the penalty will go.
Yes.
Show me the law on that.
No, No, that's not. The penalty I have put it in under challenge. They cannot withhold my retired benefits on the basis of that this matter is sub judice.
Show me the law on that.
Yes, sir. Your lordship will kindly see my
First impugn order.
just. Your lordship will see the impugn order at in the IA, that is 2702 of 2024.
Yes, page number.
Page number 13. It will get a rule 45 regulation. Idea, sir.
Rule 45.
And this rule 45 is quoted in paragraph number 9.
So what is the order of penalty? Dismissal?
No. 10, just
Reduction of the basic pay by 10 stages of increment.
That's a major penalty under.
That's a major penalty. Well, I have taken instruction with due difference to what my learned here is saying. I've taken the instruction. His gratuity amount is around rupees 20 lakhs. Bank is agreeable to pay 50% of the gratuity minus any loan liabilities that he may have.
Why 50%?
Well, or the matter
Supposing
matter may
the
be taken up for
penalty,
hearing. We have no difficulty with that.
supposing the penalty is sustained,
Lordship.
then also it is about reduction of 2 stages of basic.
Yes. No, 10 stages.
Huh?
10 stages.
10 stages.
10 stages.
Well, the difficulty that we are having otherwise is in computation knowledge. We can only have a rough figure. Based on that, my instruction is that 50% of the gratuity, subject to hearing, if this matter can be taken up for hearing on any date convenient to your lordship. If that be so,
50% of gratuity and
50% of the gratuity, my lord, which would be around, my lord, 9 to 10 lakh rupees, minus any loan liabilities that he may have. Because the difficulty that we are having is that it is very difficult to compute on an abstract figure, my lord. That is the
What is the abstract figure here?
my lord, the 10 stages of increment, my lord, every month, my lord, and the increment has to be, my lord, calculated on that basis. So that is there is a practical.
Calculated on the date of the order of penalty.
My lord, I have taken instruction, it's still difficult.
No, your instruction is binding on you.
My
not on
lordship
the
may
court.
direct, my lord, that immediately, my lord, that 50%. maybe.
May I also propose, since the proposal? Let them pay me all my retired benefits. Your lordship will record my undertaking that if suppose if I lose the case, then I'll pay it. What's that?
No, that's not possible. Assuming that the order of penalty is maintained,
Lordship.
because ultimately the court may dismiss his writ petition or allow it.
Lordship.
If it is allowed, no problem.
Lordship.
If it is dismissed, then it will stay.
Lordship.
So taking the order of penalty to be effective as on the date of issuance of the same,
Lordship.
whatever is his retirement benefit, you have to pay him. Why
Yes,
you can't
my lord,
compute?
my lord, we have attempted to compute, my lord. Roughly a
The
figure of.
claim over the balance amount would be subject
Yes,
to
well,
outcome
that
of the
it's a
writ
little
petition.
difficult, my lord, technically to compute that amount because we have 10 stages.
Then
of
he will
increment.
compute it and give it to you.
Lord, if he can let him.
What is the difficulty in this?
No, there is a difficulty. I have taken that instruction. my lord.
You explain the difficulty.
Lord, the difficulty is that, my lord, 10 stages of increment because there is another penalty also which has attained finality in respect of him. my lord. There are two different
is not the
penalties.
subject matter.
No, that is not. I am not saying this is subject matter. What I am saying is that when we calculate, my lord, the increment part, my lord, every month we have to, my lord, calculate on a.
When did he
hypothetical basis.
superannuate?
Lord, he superannuated in
31/7
July, 31st of July. 31st of July.
31st of July 20.
July 2024.
Yes. Your lordship may see the impugn order at page 49 of the writ petition.
Give me the writ petition.
Page 49 of the writ petition, madam. Where is the difficulty, madam, if your lordship looks into the reduction of basic pay by 10 stages with cumulative effect? They have already calculated that it will come.
So you pay him the retirement dues by implementing this
Lordship.
after deducting the
Lordship.
loan liability.
Lordship.
That is the ultimate thing you will do.
Yes, that is the.
And if you succeed in the writ petition, the balance you will be entitled.
Lordship.
As simple as that.
Lordship.
Now, if
Sometime
your
in
lordship will say, this is the impugn order at page 49. Then I came before the High Court. Your lordship will kindly for a moment see the order of the High Court at page 53. The operative portion at page 53. In view of the above submission made, well, page 53, in view of the above submission made, where is this court's find reasonable? The petition is disposed of with the direction to the respondent authorities not to give effect to a portion reduction of the basic pay till appropriate decision is passed by the appropriate authority. Now your appellate authority's order is at page 55, your lordship will see. This will not stand scrutiny of any law, my lord, page 55, my lord.
Mr. Kaur, you are a senior counsel. Make up your mind. Do you want final decision in the writ petition or you want an interim order? You can't get the final relief in an interim order. It's not possible here.
My lord, anyway that
What
is
do you
convenient.
want?
No, anyway that is convenient to this honorable court.
Then we'll fix it in January.
No, that interim order, if your lordship passes it today, then your lordship will fix the matter for final disposal in January.
No. Interim order today, matter comes up in February, March.
Yes.
Or no interim order today, matter writ petition is taken up for disposal
No,
in
no,
January.
yes.
Option A, option B. Only two options, no four options.
Yes.
Yes.
Interim order and February, March disposal.
So you implement this as per your order of penalty, whatever is his dues, you give him the correct exact figure of retirement benefit after adjusting loan liability, if any.
Lordship.
The entitlement of the petitioner to receive the balance amount would depend upon the outcome of the writ. Yes.
But as per the impugn order, there is no loan liability. It is only 10 cumulative stages.
So if there is,
No. Loan liability doesn't mean that.
Mr. Kaur, please think before you say.
Yes, yes.
Will the impugn order reflect about loan liability?
No.
But Mr. B.D. Kaur, learned counsel, senior counsel, assisted by
Yes,
Mr. H. Agarwal, learned counsel appearing for the applicant stroke writ petitioner. Also heard Mr. A. Ganguly, learned counsel appearing for the opposite parties, respondents. Stop. The writ petitioner, no, the applicant writ petitioner is an ex-employee of Assam Gramin Vikas Bank. Full stop. During the period of his service, a departmental proceeding was initiated against him. Wide, which is the notice?
Yes, ma'am. Just a moment, madam. Just a moment. So cause notice.
22 minutes.
Wide, show cause notice dated
5/11/2015, my lord, at page 22.
show cause notice dated 5/11/2015.
Page 22.
Full stop. In the departmental proceeding, it was found that the charge brought against the applicant was established. Therefore, by the order dated
Page 49.
2019.
order dated 28/2/2019, the penalty of within quotes reduction of basic pay by 10, figure of 10, as in bracket TEN, bracket close, stages with cumulative effect to page 49 of Pabori petitioner, signed out. Cumulative effect was imposed upon him. Full stop. Being aggrieved by the order of penalty dated 28/2/2019, the applicant had preferred an appeal
Yes,
before
ma'am.
the appellate authority. Full stop. However, since the appeal was not considered, he had approached this court earlier.
No, my lord. Since my pendant, before approaching the appellate authority, I came before this honorable court, then the appellate
Then you
authority
write
is
like
at page
this.
55.
Aggrieved by the order dated 28/2/2019, the petitioner had approached this court by filing WPC number 2043 of 2019, which was disposed of by the learned single judge by order dated 29/3/2019, granting leave to the applicant to prefer an appeal before the authorities with a further direction not to give effect to the order of penalty till the appeal is disposed of. Accordingly, the applicant had preferred an appeal which was rejected by the appellate authority by order dated
Page 55, 24/2019.
24/2019. Aggrieved thereby, the petitioner has once again approached this court by filing WPC number 2817 of 2019, which is pending disposal before this court. In the meantime, the applicant writ petitioner has retired from service on attaining the age of superannuation with effect from 31/7/2024. Full stop. The instant IA being IAC number 2702 of 2024 has been filed by the petitioner seeking a direction upon the authorities to. What is the letter dated 31/7/2024?
Page 13.
What is the letter about?
But they have stopped it at page 13.
Retired on attaining age of superannuation. However, due to the order of penalty imposed upon the applicant as stated above, and the pendency of the writ petition being WPC number 2817/2019, by issuing letter dated 31/7/2024, the retirement benefits of the applicant has been withheld by the bank by invoking Regulation 45. Regulation 45 of?
Regulation 45 of Assam Grant of paragraph 9.
VB AGVB service regulations.
2010.
Full stop. Agree thereby, the applicant has approached this court by filing IA Civil 2702/2024 arising out of WPC number 2817/19, inter alia, praying for setting aside the letter dated 31/7/2024 and also to issue a direction upon the bank to release his retirement dues, which would retirement dues, full stop. Mr. Moore, learned senior counsel for the applicant, submits that his client is ready and willing to give any undertaking to refund amount found due and recoverable by the bank in the event the writ petition is dismissed. Therefore, full stop delay. Therefore, the present is a fit case where the IA deserves to be allowed, as otherwise the applicant would be subjected to serious prejudice. Full stop. Responding to the above, Mr. Ganguly submits that the bank is willing to release 50% of the retirement dues of the applicant after adjusting loan
liabilities, if any.
Loan liabilities, if any, availed by the applicant. However, the exact amount of retirement dues cannot be released at this stage since there are computational difficulties on that behalf. Full stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record. Full stop. There can be no doubt or dispute about the fact that although writ petition in the form of WPC number 2817/2019 is pending before this court, where the order of penalty dated so-and-so is under challenge. Yet, even if the petitioner fails in the writ petition, even then, he would be entitled to receive retirement dues, which can be computed after taking note of the order of penalty dated
28/2/2019.
28/2/2019.
Page 49.
Therefore, there cannot be no justifiable ground for the bank so as not to pay the applicant his retirement dues on the basis of the order of penalty dated 28/2/2019. Stop. Such being the position, this court is of the opinion that the applicant has made out a prima facie case for issuance of a direction on that behalf upon the respondent banks. Stop. Therefore, this IA is being disposed of with a direction upon the respondents to release the retirement dues of the applicant as applicable on the date of his superannuation by treating the order dated 28/2/2019 as final. Full stop. The amount due and payable to the applicant on such count shall, however, be subject to adjustment of loan component, if any, availed by the applicant from the respondent's bank. Full stop. However, the release of such amount, the amount shall be released within a period of 60 days from the date of receipt of a certified copy of this order, failing which the same will carry interest at the rate of 9% per annum from the date of this order till realization. Full stop. Insofar as the claim of the applicant on the balance amount is concerned, the same shall be subject to the outcome of WPC number 2817/2019. With the above observation, the IA stands disposed of. And in writ petition, you write so-and-so for the petitioner, so-and-so for the respondent. On the request of learned counsel for both the sides, let this matter be listed again in the 4th week of February 2024. You get your 25, you get your money, then if no money, then there is trouble. You have to pay him.
No, no,
because
we'll-
That's the maximum you can do.
We'll definitely.
You can't
But this is
say,
not a case of
sales
dismissal.
will not give you 50%, will not give you anything. You can't do that.
No, the IA is dismissed.
IA is
Yes.
dismissed.
We are blessed.
For hearing, item 15.
Although the matter is listed for hearing, it is related to a departmental proceeding on which the petitioner was given a compulsory retirement. And he expired. In the meantime, we have filed two IAs. One for condonation of delay by his wife for the substitution petition, and the other the substitution petition. But once she's substituted, perhaps you can proceed on the matter. On the last occasion in the writ petition, there is an order that the cause of action survives. Therefore, the substitution is necessary. Those IAs have come on record. On the last occasion, they were not on record. If today Lordship allows the condonation, if he does not have an objection.
No, my lord, the IAs have come for the first time, my lord. Let notice go, my lord, because it's fixing a short date, my lord. If required, we'll file objection. Also, also may allow.
That would also do.
May allow this,
So order of compulsory retirement,
my lord.
is it not a personal cause?
My lord, the retirement benefits which flow after the compulsory retirement, the family pension will come. Person had agitated that he was not required to be compulsorily retired. If that order of compulsory retirement goes, he would be in service till the date of his death. The family pension, which the wife would be entitled to, would then increase. He had agitated his cause. It is not that he died without agitating. He agitated throughout his life, he fought. So therefore, that
Okay, what is the IA? Where is the IA?
my lord, IA number 3379 is for delay, condonation of delay, and 3380 is for the substitution.
Which is condonation of delay?
3379, my lord.
IA number 337. 337, yes. Then we'll issue notice, but you will accept notice, Mr. Adhikari?
Yes, my lord.
It's on the department authorities.
Heard Mr. R. Majumdar, learned counsel for the applicant. This IA has been filed under Section 5 of the Limitations Act 1963 with a prayer to condone the delay of 1 to 81 days in filing the substitution petition in WPC number 6462 of 2015. I have perused the grounds stated in the IA, full stop, issue notice returnable in 3 weeks. Since Mr. M.R. Adhikari, London CGC, has appeared and accepted notice, all the respondents, no formal notice is required to be sent in this case. Extra copy of the IA be furnished to Mr. Adhikari within 3 days from today, so as to enable him to file objection, if any, within 2 weeks.
My lord.
It is made clear that on the next date fixed, the IA will be taken up for final disposal.
My lord.
I'm
Obliged.
Item 15.
May it please your lordship, my lord, this writ petition was filed in the year 2015. The petitioner before your lordship is a company secretary who was cleared the examination of company secretary. She was the third lady from Assam. In 1995, my lord, she was appointed as a company secretary, as assistant company secretary. Thereafter, she was promoted and ultimately became the company secretary of Assam Industrial Development Corporation, that is AIDC in Juro. Her grievance is, my lord, that in regard to stagnation in her service, and just to deprive her the increase in the pay scale after the coming into force of the ROP 2010, there was some there's a scheme called SLAS. I'll take your lordship to the scheme. They say that we have partly adopted the ROP 2009 AIDC, and she was sought to be denied the increase in the salary, because if she doesn't have a post also, at least the salary component should have increased. That is not there in this case. So basically, we have come against stagnation in service, my lord. That's the whole issue behind this writ petition. And after filing of this writ petition in 2015, one so cause after another has been issued against him. Sometimes even if she comes to the court to attend the proceeding, then also a so cause is issued. If she goes on leave, so her predicament continues after 2015 more. So I request your lordship to hear this matter and finally dispose of it, because it's a 2015 matter. We can proceed, madam.
Who is appearing for the response?
4 and 5, lordship.
All the pleadings are complete.
4 and 5.
Yes, 4 and 3.
1, 2, and 3, who is representing?
State has not much role to play because it is AIDC is a independent undertaking, my lord. But even then they have.
Lordship, the ROP is from Finance Department, Lordship. It is
Yes.
3. 1, 2, and 3 is necessary.
At some point of time, good dog will
Yes.
appear. No, fine. Good dog will appear.
So are you aggrieved by the pay scale or? you are-
Stagnation in service. Not by-
Stagnation,
not by the
nothing
pay
to do with pay scale.
Nothing. Pay scale is there because AIDC has adopted a particular grade pay of the ROP 2010 because you cannot adopt simple only a grade pay. You have to always grade pay is against a particular post in the ROP. So they have just taken out a grade pay which was alien to AIDC, my lord.
All right, now these pay, etc., this is a corporation, government corporation.
Yes.
So is the accountant general not required to be heard?
No. only
Finance department will
Finance,
not.
yes. Finance has appeared
Finance
earlier.
required.
Buddha Gogoi had appeared, my lord.
The finance required.
Finance had appeared. They had appeared, my lord.
Finance is not a party here.
The
No,
finance
the-
is the party.
Yes.
Okay, respond number 3.
Yes, Lordship.
And finance department, my lord, due to my stagnation has sought clarification from the AIDC. AIDC sought not to reply to the finance department query. That your lordship may find at page 139, even page 96 also. The first clarification was sought at page 121, your lordship will find. Page 121 will be the running page, my lord. It will be in affidavit in reply by the petitioner, my lord.
So there is no promotional avenue for a company secretary.
No.
And you are aware of that.
Next post is general manager. So I will be entitled to the pay scale of the general manager to avoid stagnation. But what they have done to deprive me the pay scale of the general manager, they have just put a grade pay, which is I think as increment of 200 rupees. From all these years, I've been only getting a grade pay increment of 200 rupees.
You are appearing for the finance department, Mr. Shelly. What is your stand here?
Lordship, here we have received our instructions, Lordship. Here, the particular stand of the finance department, Lordship, if I may read it, Lordship. The ACPS, MACPS is for regular state government employees, and finance department is not in a position to offer any views on the service linked advancement scheme, which is not under their purview. The MSCA ACPS does not extend to employees of AIDC. As such, administrative department may be advised to take its own decision, my lords. That was the stand that has been so far taken by the finance department, because we do not have the particular records also of the employees, lordship. So we were implemented later on, lordship, and on the basis of this instruction, lordship, this was the instruction which we had received from the department.
And this is in our support. AIDC was always trying to throw the ball to the finance department.
So then will it not be helpful to you if this is placed on record in the form of an affidavit?
We can file an affidavit, lordship.
Mr.
We can bring it on record, lordship.
I have no.
Otherwise, I will not take note of this submission.
No, lordship.
There has to be an affidavit.
Lordship may grant us some time.
If you don't want it, then we'll proceed in that direction.
No, lordship.
But then the consequences will follow. If you want to rely on the stand of the finance
Because
department,
this is in our support.
up to you. What do you want? Affidavit to file or not file?
Lordship will file an affidavit, lordship. Lordship will at least grant us 10 days time, lordship, because we'll have to file the affidavit and for signatures, lordship, 10 days.
Oh, that's all right.
Yes.
What do you say?
But that will be because this is in our support, Palon.
Then
He's in
let it file
agreement,
an affidavit.
lordship.
But your lordship will kindly fix the matter earlier because this is a 2015 matter. This petitioner is more one.
Let him file the affidavit in 2 weeks.
Lordship, yes, lordship.
And your lordship will.
Not Mr. Vidikol and senior counsel assisted by Ms. Swenson and counsel appearing for the writ petitioner. Also heard Mr. H. earlier, learned standing. You write like this. Also heard Mr. J.K. Goswami, learned additional senior. You are appearing as additional.
Standing counsel, standing counsel, yes.
AIDC appearing for the respond numbers 4 and 5. Mr. And who is appearing for the state of Assam? Mr. H. Solia, Learned Standing Council, Finance Department, Assam, is present on behalf of the respondent number 3. How can you be for respondent number 4? Industries and Commerce Department also you are representing.
Anjan Kolita is there.
Acha, H. Solia for 3, Mr. N. Kalita for 5.
I am 5 and 6, Lordship.
And Mr. J.K. Goswami, Learned SC, AIDC for respondent numbers 5 and 6. None has appeared for respondent numbers 1 and 2 when the matter is called up.
M Sokroti may be.
Huh?
M Sokroti, his name may be recorded. She was
No, but where is she? She has not appeared.
at this moment.
You take down. The primary grievance of the writ petitioner in this petition is that by manipulating the grade pay under the revised pay scale, the petitioner has been placed in a situation whereby there is no promotion, there is no scope for career advancement of the petitioner. System. The respondent AIDC is also refusing to extend any MSCP benefit to the petitioner despite her long years of service in the same post of company secretary under the AIDC. System. Mr. Cholia, Learned Standing Council, Finance Department, Assam, submits that he has received instructions pertaining to the plea raised in the writ petition and seeks 2 weeks' time to place the same on record in the form of an affidavit. Considering the nature of controversy involved in this writ petition, there is consensus at the bar that the stand of the Finance Department, Assam, would be relevant, would have a relevant bearing in the outcome of the writ petition. In view of the above, Mr. H. O'Lear, Learned SC Finance is granted 2 weeks' time to file affidavit in the matter. This case again after 2 weeks as a fixed item.
Lordship, I may be furnish a copy of the affidavit, Lordship.
We'll do
5 and 6.
Maybe our Lordship will indicate.
Give them what is.
Yes, Lordship.
Well, may I pay for a fixed date?
I have already said after 2 weeks fixed date.
Lordship.
There is one IA, my lord,
Yes.
for correction upon typographical error, my lord. That is page number 3 of the writ petition, para 2. Para 2, last line, dated 1/4/12. This should be at 8/4/12.
Typographical error in
writ petition,
My lord, para 2, line
para
3.
2, line 3. Writ petition. Dated 1/4/12 should be 8/4/12.
All right, so this is amendment of writ petition.
Yes, ma'am.
Kind of amendment of writ.
And my lord, one more thing, my lord. Unfortunately, while filing the writ petition, one of the document pertaining to NIJ 2 series have not been properly filed. I may be allowed to correct that.
No, have you mentioned it here?
No, that just now I have detected that.
Oh, then why don't you, because nowadays the problem is 20 years back, it was all done like this. Now every piece of document has to be in the CIS. It will not go into the CIS.
So I may be allowed to file affidavit for that.
Then why don't you either withdraw it and file afresh or file additional affidavit? Additional affidavit will also not do. These are the problems. Every bit of document now has to be in the CIS and they will not take it in the CIS unless it is done through proper procedure.
Actually, my lord, only
You understand what is CIS?
Yes, yes.
What is it? Tell me. What is it?
Center Information System.
No. Case information system.
Case information.
What do you want to do? If you file an IA, then I will allow it. Otherwise,
I will file IA for correcting that.
then you withdraw this and file afresh.
This should be,
You withdraw this and file afresh.
this IA.
Yes,
Okay, I am withdrawing this.
incorporating. You understand what I'm saying?
Yes, yes, my lord.
And check up if there is anything else. Mr. So-and-so and counsel for the applicant submits that there is some defect in this IA and therefore he be permitted to withdraw the same with liberty to file afresh. Mr. B. Decker, CGC, appearing for the respondents, does not have any objection to the above Prayer. In view of the above, this IS is disposed of on withdrawal with liberty to file afresh.
It's 17.
In this matter, earlier occasion it was directed to make ready the relevant records pertains to department proceeding. Malad. In fact, Malad, the records is before your lordships. It's in a Hindi version. And in fact, Malad, another aspect, Malad, all these documents in the affidavit is incorporated in the translated copy, Malad. That means the impugn order, subsequently appellant order, everything is in the English version is there. But here, what has happened in the department, I have seen that some English is there, mostly the Hindi. Otherwise, the facts will, everything will be revealed in the the pleadings and the translated copies is there.
So what is the problem? Hindi is okay.
Just I just informed it because Hindi it is difficult for me also.
For?
For me also.
For you, it is difficult.
It is difficult to read out the English version is there. Malad.
So you tell me what is there. I have no difficulty with Hindi. I can read it.
Malad.
If you want, if you have any problem, then.
No, Malad.
Right. Yes. What is the matter, Mr.
My letter here, the petitioner was appointed in 2009 as constable in CICF, my lord. And my lord, because of unauthorized absence of the petitioner, my lord, for the period from 5/7/16 to 16/11/2016, lordship. That is 4 months, 11 days. It would be absent, my lord. And lordship, have a look, my lord, that charge number. This is para 4, my lord, page 8, my lord. Charges have been framed accordingly, my lord, by them, my lord.
Page number?
Page number 8 of my writ petition. 8 and 9, my lord. Para 4, lordship. I have stated regarding this charge. The official remained absent from duty with effect from 5/7/16 without any information and or permission from the competent officer. Thereafter, 5 call letters were sent to the officials to appear in the unit to discharge his duties, but he neither replied to the call letters nor has appeared in the unit. The official has been deserted since 5/7/16, and the act of the official being a member of a discipline force shows his negligence towards duties, gross indiscipline, and defies to orders duly passed by the competent officer. Charge number 2. In short duration of service of official, he has already been awarded 6 minor punishment under Rule 37 of CICF rules and 2 major punishment under Rule 36 of CICF. For his various negligence, indiscipline, and misconduct. Despite that, he has not brought any reformation of his negligence in discharge of his duties and misconduct. This kind of act on the part of the member at discipline force shows his negligence toward duties and indiscipline. This is charge 1 and 2. Now, lordship will find the impugn order at Annexure D, lordship. Annexure D, that is, lordship will find the impugn order.
Page number?
Page is 38, lordship. 38. So
This final order was passed on 31 January 2017, my lord. This is that article of charges 1 and 2, which I have read out. And lastly, lordship will find the operative portion at page 52, my lord. 51 and 52, 51 last, my lord. I, the undersigned, have found the charges framed against the charge official proof on the basis of the available documents, statement of the prosecution witnesses, and the documents exhibited by them. The charge official was given ample opportunities to defend himself, keeping the principles of the charges in view. But the charge official has failed to adduce any evidence or document in his defense. The conduct of the charge official shows his gross negligence towards his duties in discipline, defense to the orders given by the higher officers, and his whimsical attitude, besides showing his irresponsibility towards his service and tarnishing the image of the force. The charge official was given opportunity to reform his conduct and was reinstated in service twice, but he has failed to bring any reformation to his conduct. Hence, the charge official is not fit to be kept in service in armed forces. The offense of the charge official is grave in nature, which deserves strict punishment. Hence, in excess of powers conferred by Rule 32(1) and Rule 34(2) of the CICF Rules 2001, I award the punishment of removal from service to force number so-and-so, Kumar Chetri, CICF unit L further, which is proportionate to his offense. Force number so-and-so, GD so-and-so, unit L, so is informed that if he intends to prefer any appeal against this order, he can do so before the Deputy Inspector General, not so-and-so. This is the charge, this removal order, my lord, of the petitioner. My lord, since
So an inquiry officer was appointed and a detailed inquiry was
my
held.
lord, yes.
Departmental
My lord,
inquiry was held.
Here, yes, my lord, here only my grievance is this, my lord. Since 5/7/2016, my lord. 5/7/2016, my lord. Since the petitioner suffered from mental imbalance, my lord. That is why he came home, my lord, and he treated in Dibrugarh itself, my lord. With
So
the
what is
doctor.
his reply before in the departmental proceeding? Let us see his
My
reply.
lord, this is one aspect, my lord, medical. I'm just coming to lordship. And secondly, my lord, when the inquiry was held, my lord, that is, lastly, they wrote a letter, my lord, that is in their affidavit, it has been reflected 5/10/2016 to call up the delinquent, which he did not receive. Subsequently, at home, at his home, the official visited and asked him to join in the duty. And this letter was shown by them 5/10/2016. My lord, when during the treatment also, when he went to the office itself, my lord, with his brother, my lord, then the charge memo was handed over to him on 1/11, my lord. That is, and subsequently, my lord, the inquiry was conducted without knowing anything, without giving any assistance, without giving any list of date, without giving any giving opportunity of hearing, my lord. That part I have stated in my para 9, my lord. In my para 9 of petition, my lord. Lordship, kindly have a look, my lord.
Yes, but my question is slightly different. Did he submit his show cause reply?
My lord, show cause reply, my lord, only they have shown, my lord, one reply was given by the petitioner, showing that
Where is that reply?
in their affidavit they have enclosed, my lord.
Page number?
Page number 126, lordship. 132, I'm
132.
132. 132 and 133 is the later annexure 5 of the affidavit. My lord, here this Hindi was written, found to be written, but whereas lordship has got it.
Annex 15, my lord,
No, 15 no. Annexure 5.
Annexure 15.
In Hindi
So,
version,
Annexure 15, page 126. Please read it.
it's one.
What is
My lord.
AWL?
Lordship,
AWL means
unauthorized leave. Absent without leave. My lord, they say that inquiry report was submitted and accordingly, this reply was given by the petitioner. The petitioner was signed in the English, my lord. He does matriculate, my lord. He doesn't know how to write all this Hindi. Somebody wrote this Hindi and this he signed it, my lord.
no, but
Here,
are you denying that you have not submitted this?
no, I have not been I have not been provided the inquiry report. And had there been the
Mr.
inquiry,
Chetty,
Lord.
this is the problem. I am asking
Lord,
something.
I'm sorry, Lord.
Did you submit this reply or not?
No, my lord, factually, I signed. This is correct, but I did not know the contents.
Before any other bench without me. I can't hear a matter like this. You are making all fundamentally goofed up submissions. I am asking you, did you submit this reply or not? You said you did not submit, but you signed. What kind of an answer is this from a council of your standing? This is your reply.
Yes.
Then why are you saying no?
Now.
Then he will say that then we want to hear the petitioner himself. Because then he will say, I have not argued anything. I have only engaged a lawyer. Is this a stand you take before the High Court?
No, this is what I'm saying, my lord. Yes,
Did
my
you
lord,
submit
here,
this
my lord,
reply or not? Yes or no?
Yes.
Yes. So in that reply, you did not mention about any mental ailment.
No.
You said family problem.
Here, family problem has been given, my lord. This is.
Yes. Yes. Okay, please.
My lord, here, then lordship will find their notice, my lord, last notice, which they sent to the petitioner, my lord, to join. That is, my lord, at page, since page 193, lordship. Of the affidavit, my lord, 193. That is only kiba simply.
Yes.
Lordship, kindly have a look at Annexure 11 of their affidavit.
So did you submit any reply against the letter dated 3/1/2017 at page 124, annexure 14?
Yes, that has been shown, my lord. I have already supplied submitted the reply, my lord. My lord, only, my lord, since my lord, this inquiry report that has to be supplied to the petitioner, my lord. That was not supplied to the petitioner. Only that pen and papers, it has been, these formalities has been completed, and I have told to submit an application. Accordingly, someone write the letter, and accordingly I submitted the letter, my lord. This, but my lord, factually, I have stated in my repetitions at para 9 and 10, my lord. Specifically, I have stated, my lord, 9 and 10. Which has not been denied by the respondents in their affidavit, my lord. Categorically, I have gone through it. Lordship, kindly have a look, page 9 and 10, my lord.
Page or paragraph?
Sorry, so para 9 and 10, my lord. 9, petition had been removed from service by the so and so, for so and so, unfair department person in country to rule 36 of 2001 and article 311(2) of the Constitution of India, as well as the other settled laws. The petitioner was under the continuous medical treatment due to his mental illness since 10/7/16. However, the authority was informed, but it was totally ignored at the relevant time of inquiry. It is mentioned that the said AWL was neither a deliberate attempt nor intentional. As such, the impugn action to so and so by initiating back departmental inquiry in violation of principle of natural justice, and hence the interference of this honorable state. Further, it is stated that the impugn removal order so and so issued by the respondent number 5 to the petitioner to the absent without leave is itself disproportionate to the gravity of the charges. Now, Lordship 10, I have stated everything, my lord. That the petitioner said that on 24/11/16, a copy of the memorandum was furnished to the petitioner, and accordingly, written statement was submitted on so and so, denying the fact of allegation, etc. Accordingly, the disciplinary proceeding was initiated against the petitioner by appointing inquiry officer as well as the presenting officer on 6/12/16. And accordingly, from 14/12/16, the statement of witnesses SPW1 to PW4 and CW1 and C2 were recorded by calling them. However, the petitioner was kept in dock for cross-examination and shown to be present at the relevant time and obtained the signature without having his knowledge about the proceeding. However, the respondent authority was failed to follow the provisions of Rule 36(4) of CSF Rules 2001, as well as Rules 36 within bracket 8A and 10B, Rule 36(19) and 21(22). It is to be mentioned that while the petitioner was undergoing medical treatment for mental disorder from so and so, the respondent's authority initiated the proceeding just for formality's sake, even without delivering the copy of article of charges, the statement of imputation of misconduct, the list of documents and witnesses to submit his written statement of his defense, and to state whether he deserves to be heard in person. No official assistance was provided, my lord. And my lord, provided to assist the petitioner for the entire proceeding, my lord. And no reasonable opportunity was given to the petitioner, my lord. Here, my lord, this whole action was done, my lord, this inquiry was done when the petitioner was continuous in the mental agony. And
so where is his mental treatment document?
Lordship will find at page and it starts from page 30, Lordship.
Page 30.
30, Lordship. Page 30, 10/7/16, Lordship. It's continuation, my lord. Lordship will have it, my lord. 10/7/8 to 17, 15 to 17, 16, 11, 17, my lord.
So the petitioner is, where does he belong to? Which place?
Dibrugarh, Lordship.
Is a person from Dibrugarh.
Dibrugarh.
This is a private practitioner or a government doctor?
This is a government, my lord. Medical officer, my lord.
So where is it written that he is suffering from?
Dibrugarh State Dispensary, my lord.
No, where does one find that he is? Mentally unfit?
Lordship will, this page 36.
Sleep deprivation.
There has been suffering from psychosis, mental imbalance.
Where page?
Page 36, Lordship.
So you want reinstatement?
Reinstatement, my lord.
So where is the medical certificate that he is now mentally fit?
Here, my lord.
Did you
Was
place
under
any
my
such
treatment.
certificate before the authorities?
This is next para of the page 37, my lord. This is last line. my lord.
And in your reply, you said that is a family problem.
Family problem that that has been given, my lord. Here, since the mental imbalance may be cause for this family problem or anything else, my lord, but the mental problem is there, my lord. Mental imbalance.
All right. Anything else?
My lord, nothing, my lord. Since this petitioner, my lord, since he was under the treatment, that is why, my lord, whatever the action was taken cannot be treated to be in bona fide, my lord. And since it was done when he was under the treatment, my lord. And whatever the action was taken by the authority concerned, just it was an IWAS inquiry, and no such formalities or the procedure was done completed. Since the petitioner was not aware about all these proceedings, he was not given even asked for the assistant, my lord, since he is only matriculate, my lord. He doesn't do the proceeding of this discipline. Now, even for us, my lord, sometimes it creates problem to go through all this, the one by one statement, all this, the cross-examination, nothing was done, my lord.
Where is the written statement submitted on 3/12/2016? You have mentioned it in your writ petition. Where is that written statement? Page number?
Here, yes.
In page 15 of your writ petitions, first line.
My lord, that was not there, my lord. That is why it is already.
Did he submit written statement?
No. I cannot find out much. There was no written statement, my lord. Simply it was.
No, Mr. Goswami, what I'm asking you is, after did he submit any reply, any statement, any show cause reply before the authorities?
No.
In fact, Malad, that next of 15 document, that is the reply submitted by him, Malad. And another
So that is after the inquiry report was given. Before that,
In fact, we repeatedly, from the document,
answer
because
the
that
question.
we repeatedly try to communicate him.
Hmm.
He denied, even he denying not received the documents. After at last, Malad, we asked the Departmental some CISF unit person to go and deliver it. Then he come to know because his mother received from documents reveals his mother received and he did not dare.
So
Then he come.
where is the statement that your officials went and have you stated in your counter affidavit?
Malad, it is volume is paragraph 3 onwards, Malad.
Hmm.
Paragraph 5, Malad, sorry.
Paragraph 5.
No, replying to the paragraph 3 of the petition, Department denying same backs that they bring notice of the honorable court that so and so shift duty on so and so. Yes, but he did not turn up on for duty for and was found absent without prior permission of the complainant and finding the petitioner absent on duty, he was searched nearby place, unit like so and so, so and so.
And at that time, he was posted at Hardwar.
Malad. But he remained untraceable. Further, he was also found absent for evening counting parade, to which he was declared absent without leave. 3 call-up notices were sent to his native place through registered post, white later dated so and so, so and so.
You're reading which page? Page number?
Well, page 4 of the affidavit, the paragraph 3, the paragraph 5, second page,
Hmm. Yes.
Further, he was found absent, so and so, so and so, absent without leave. 3 call-up notices were sent to his native place through registered post by so and so, so and so, so and so. Those are annex as annex A1, 2, 3, And after remaining absence without permission, the competent authority for 44 months, 19 days, so and so to this period, the petitioner reported back to unit on 24/11/2016 on his own. The petitioner received the search memo issued by Departmental on so and so and so and so, and submitted his reply on 3/12/2016.
Where is that charge? Where is that reply? I'm asking.
Malad.
Where is that reply?
Malad, I'm kind. Annex of 5 to the Malad, our affidavit, Malad. Page, Malad. Page, Malad, 57 of the affidavit opposition, Malad. Jealous has got it.
Hmm.
The Hindi version is next place. I force number so and so. Kumar Sethi working in this office since 14/5/2016. I remain AWL from this period. Sir, my reason for AWL was due to my family problem, which I didn't have any idea what to do. Due to this, I remain AWL from this period. Due to this family problem, I was very upset and I did not understand what to do, which I remain AWI. Sir, I request you to that I will never do such work in future and will do my duty. Sir, being a force member, I take this oath and I will never make such mistake again in future. I look.
CISF rules. CISF rules 2001.
That's kind of mistake appears from the his earlier also he has done, twice he was removed. Then appellate authority,
Twice he was removed
my lord,
earlier.
my lord, that is, those documents are before losses in the affidavit, the position we bring it today.
Let us see where are these statements.
He, those, in both the occasion, he was reinstated by the appellate authority. And once most probably revisional authority. And then try to allow him to try to his pay was in the reduced rate, but he was not man by himself, my lord. That is why.
So where is the statement that he was removed twice?
My lord. Well, page 6 of the affidavit of position in the pleadings, my lord. As ever by the petitioner is under treatment of medical officer of MBBS degree, whereas the mental imbalance for which the petitioner is taking treatment require consultation with the specialist doctor. Moreover, during the course of the inquiry, individual never produced any such medical document which itself reveals that the lie being averred by the petitioner before this honorable court, and that he was suffering from mental imbalance. The petitioner, in his short service, 7 years in CISF, has been awarded 2 major penalties. Both the occasion he was dismissal from service, and 6 minor penalties for remaining absent in duty without permission and competent of the competent authority, and for overstaying the leave.
So
He
these
was habitual
have been denied. They have denied in affidavit in reply.
Hello.
Has this been denied?
No, my lord. The documents are before lordship, my lord. That cannot be denied, my lord. Page 67, that is the appellate order. The last occasion he was reinstated in service. Operative portion at page 75.
So this time the appellate authority,
My lord, if this time what happened in the CISF rule, my lord, the rule 47, it says that the appeal is required to be submitted within a stipulated period of time, that is 30 days. He, in the instant petition, he challenged the appellate order also. In the appellate order, it is clearly mentioned. There is a delay in approaching, that is why it is binding, hands of the appellate authority is binding. They cannot pass any order beyond the 30 days period. And subsequently, he says in the pleadings that with the revisional authority, our optimum authority is the revisional authority. He says that the revision order, but in the affidavit in opposition, we bring it to knowledge of the court that the revisional authority also passed an order denying his reinstatement, my lord. That is the order dated, my lord.
That order was
28/6/2000. Petitioner submitted 28/6/2019, the petition before the revision authority.
Page number?
My lord, subsequently, it was, my lord, last annexa is the, my lord, I am coming, my lord.
69.
Page 19 is the order passed by the revisional authority, my lord. On annexa 19, my lord. 146 more only, yes. Ordered at 14/1/2020. Operative portion is at 148, that paragraph 6 of that order. Penalty has been confirmed by the revisional authority.
So this order is under challenge in this writ petition.
He has challenged this order. He says that he has not received the copy of this order. That is why I bring it to for that in by one affidavit. This order he is
no pendency of this writ petition, my lord. This revisional order was passed.
My respectful submission, your losses, that is not in fact, my lord.
My lord,
the writ petition has been filed in 2021. The order revisional authority passed on 14/1/2020.
I didn't get it.
He says that in the pleadings, he has not received the copy of the writ. That is why
page 69 of my writ petition, my lord. The application was submitted, my lord.
And where is the order of the appellate authority?
My lord.
Appellate authority, lordship will find. At page 60, lordship. of the repetition. And the 63 lordship will find para 6. Then lordship will find another order, my lord, letter, my lord, written by the commandant, my lord, page 68 lordship. That is after the appellate order, my lord, 27/5/2019. Your application has been examined by the competent authority and it has been observed that your appeal petition dated so-and-so was disposed of by the so-and-so DIG headquarters, Mohipalpur, New Delhi, so-and-so time bird by order said so-and-so. There is no provision to entertain second appeal as per so-and-so instruction contained so-and-so. However, if you desire so, you may prefer revision petition to the Inspector General CISF, NS headquarters, New Delhi. And accordingly, on the basis of this revision petition was filed. That is Annexure G, my lord. In the revision petition, my lord, this undergoing treatment at Dibrugarh, all these things have been enlightened.
Yes.
And when the matter was pending, my lord, then this revision against the revision petitions, my lord, whatever order was passed, that was produced before the honorable court. And accordingly, my lord, after perusing this revisional order, the honorable court was pleased to consider and issue the notice in this case, my lord.
All right. Please hand over the record.
Ma'am.
Will be ordered in the chamber.
Let I have some of the judgment.
Judgment on what point?
Regarding my lord, the misconduct, all this of the force, my lord, all these things, my lord. The misconduct has to be proved at parties. And lordship's judgment, I have also gone through it. And one.
Oh, Mr. Chetri, you see, the fact that he is a deserter, that is, there is no need to prove it. He is already admitted. The question is, his answer that he was suffering from mental illness, does it deserve a consideration to the extent that the court should interfere with the orders already passed by the authorities? This is the only question here. So here also he is not consistent. Right. And then he said it's his family problem. And then 2016, then past also he has same problems. He was removed from service, dismissed, reinstated. I think he should be at home. Let's give it a rest.
My lord, since my lord, in this point, my lord, our High Court decided the matter in some of the cases, my lord. which,
These are all on facts.
no.
Facts of the case.
In one case, my lord, I have found, my lord, this he was remained absent for 3 years, my lord. And considering all this aspect, my lord, he was directed to be reinstated in service, my lord. And departmental proceeding, if needed, can proceed.
There must be some infirmity in the proceeding.
No,
That's all.
my lord, since that judgments are there, and my lord, this opportunity of hearing, my lord, since my lord, when the lordship is very much aware regarding the settled position, that when a person giving this inquiry report, my lord, there must be a show cause, my lord. There must be a receipt of the inquiry report of the delinquent. That is lacking, my lord, here. Now, no inquiry report was submitted. Only the application was taken from the petitioner, my lord. This letter was taken from the petitioner. This pen and paper, my lord, here, my lord, not a single this process has been followed, my lord. The procedure which is laid down in under section.
Give the citations you give.
Lordship. This I have stated in para 9 and 10 and 13. This is very specific, my lord, which I have alleged that there is a irregularity in the procedure, and that whatever it has been cited in the section 36 of the this Assam this CICF rules 2001, that has not been complied with. It has not been complied with. So I will supply, my lord.
Next item.
Paragraph 5 and 10 of the appeal opposition, your lordship, we had explained everything. My lord.
My lord, kindly pass over for the time being, my lord. Yes, yes.
But before rising of the court, otherwise it will go to another case.
What is the? Please, lordship. What you are follow. Lordship. Lordship record is here, lordship. I received the record. At the same time, lordship, unfortunately, lordship, the affidavit from my part was not part is not filed, lordship. They have filed the affidavit, lordship. They have filed the affidavit. Affidavit.
If it has been filed.
Affidavit in opposition has been filed.
Where is it? Is it on record? It doesn't seem to be in record. Show it once.
Okay.
Oh, give it to him.
No, but they have served a copy. All the some difficulties are there, therefore we are not filing the affidavit. And lordship, kindly fix the matter after a week, lordship. We will, in the meantime, we will file the affidavit.
Mr. I. Rafiq, learned counsel is present for the petitioner on the request of Mr. J.K. Goswami, learned additional service. This matter is directed to be listed again after 10 days so as to enable the department to bring on record the affidavit proposed to be filed in the matter. And in item 18, you write on the request of learned counsel for the petitioner, hearing of this matter stands adjourned for 2 weeks. List over. Yes.
I'm sorry, my lord, I was lacking, my lord. So 18 was password by timing for.
Yes, yes. What is item 18?
Item 18, my lord, petitioner was appointed as a, my lord, constable GD under Assam Rifles. And he had joined the training, my lord, at Uttarakhand, Garhwal Hills, my lord, it is Lansdowne. During this, my lord, training period, he had some difficulties in breathing, my lord. So he had complained about that breathing, but it is.
So we'll take it up on next Tuesday. Let me first write the judgment in the. This coming
please.
Tuesday, just again on.
Obligation.